You guys are watching. Our meeting has started at 6:30 with 58 seconds. Thanks everyone for being here. As we go through a good chunk of time for 65.5 and all the questions that were, maybe not. We have about 60 sections left, if I recall.
Yeah, but I think that there's only a handful that have been
comments.
flagged. And before I turn it over to Reed to kind of preface 65.5, I just want to remind the committee that we have one meeting left in March. And that per the resolution council passed to form this committee, we were anticipated to present to them this month, but we got off to a little bit of a late start, so we're already pushed to April. So it's really imperative that we make the best use of our time tonight and at the March meeting, because trying to find time for a third meeting somewhere in there is going to be difficult, not just for all of you, but for us, because we all have other night meeting commitments. Getting into that time of year where we're doing boards and commissions interviews and appointments and trainings and all the things. And so my hope is that we can get through everything tonight that has been flagged with a comment or a question. And so that when we come back in March, we will pull out those sections that this committee has identified as wanting to either discuss further or move forward as a recommendation to council. And maybe if the committee is agreeable, either starting that meeting a half an hour earlier or going a little bit later, just so that we're not rushed for time. Any questions on that?
No, I have a question. Very short. What do you anticipate this document from this committee to look like? Is it going to be a series of questions, sentences, statements?
No. So what I anticipate it to look like is we will go back. What I will do is I will go back through everything that this committee has either said yes or no. Remember last time we started marking that when we had made comments on them. And then what I would expect, ladies, is I would create a little table, and it would have the charter section here, and then it would have kind of those committee concerns, you know, out of date or not needed. We're not looking for the committee to come up with verbiage. Okay, we're not looking for the committee to come up with what it should be worded as. That's something that would call the staff or Reed's team to do. What we would be looking for is the concern that the committee had that brought it forward.
It's a valid topic.
Yeah. Okay. Okay. Reed, you want to kick us off on this one?
No.
He's already not playing nice.
So just looking at some of the questions about 65.5, is the code being updated to comply with charter change? So what I am aware of is that an ordinance will be coming forward to require first-class mail. If folks might know that council had adopted an expanded notification process for various types of land use changes, and they had agreed to send out mailings to all affected property owners, but not first-class mail. First-class mail is something like 80 some cents now. So normally we get like a bulk rate option. So in order to comply with the charter, we will be changing that section. If we consider updating 2025, 6 regarding vested rights. I know that was a suggestion I have heard that, hey, the problem with this is that it says January 1st, 2025, not January 1st, 2026, and it could just be a simple change. I don't know if that necessarily fixes it. It may temporarily fix it, but some of the challenges with this charter provision is we now have state and federal mandates that are coming through. So obviously, one of the big issues with this one is that it takes us out of compliant with the state law requirement that required all jurisdictions to allow for ADUs any place that you can build single family. That was an ordinance that was passed by our city council. However, this state kind of makes it retroactive to January 1st, 2025. So that takes us technically out of compliance. I am aware that the state legislature is also currently thinking of other quote unquote mandates that may require changes to our code. So simply changing the date to 2026, I don't think necessarily solves a problem, but perhaps not all problems. There's an act currently going through the state legislature, which seems to have support, called the Home Act. And essentially what that would do is it would allow for, it's kind of like YIGB we talked about. YIGB was a bill last year. The difference between YIGB and there's two differences. Basically what it would allow for is any nonprofit with a history of building affordable housing, or any institution by way of state, university, school, to construct residential housing on their property. So what change that could be, I mean, it's generally okay for the city of Littleton because most of our schools are already situated in quote unquote RL zoning districts. One of the challenges would be if one of these organizations built or bought or owned property, say in a commercial zoning district, and suddenly started putting up residential or something that didn't allow for that type of build within a single family. And now they want to put up multifamily or attached or something. So that could lead to possible need for changes of our code, in which changing it to 2026 wouldn't necessarily cover that. Where's my other stuff?
Well, this is all of it, just in a different format.
Whoa.
I decided to put it all in one place for you, my friend.
Okay.
Same verbiage, just all of it.
So whether or not something is considered vested rights, it's a question that I've seen from folks out in the community, which essentially is, hey, if I had an ADU, I built an ADU, and now suddenly I'm not allowed to have an ADU because of the charter provision, what happens to my ADU? The way that we would essentially treat that as a city is it would be a non-conforming use. So you would still be allowed to have your ADU and whatever you're going to do with it. It's just we wouldn't allow for the proliferation of ADUs. To my understanding, no one has vested their rights in terms of vested is a term at, there's two terms, but there's one on common law and there's one specifically within state statute, and then our city code has ways in which you quote unquote vest your rights, and that's for all intents and purposes is pulling a building to have an ADU. That hasn't been done, so that's.
So there were no building permits that were filed in between when it passed in October or November and when the
Correct.
ADU, okay.
Yeah, I know that there was an ADU down the street, but that was actually in a location in which you could have ADUs. So ADUs is not necessarily new to the city of Littleton. We have allowed them, but it was only really in your downtown zoning districts in which you had alley load. The phrase land uses permitted under the ULUC is ambiguous. It could be read narrowly as referring to zoning classifications of principal residential uses. or more broadly to include accessory and operational provisions of the ULUC that are by ordinance. Clarifying that this distinction is important to avoid unintended consequences. 100% correct. When you go through the ULUC, you'll see that when we talk about land uses, it's in a big broad table. And in this table, we have kind of the primary uses, which are single family, duplex, multiplex. And underneath that, we have accessory uses where we talk about ADUs and won't get even more refined in terms of chickens, ducks, things like that. So there is a little bit of ambiguity to it. Currently, the way that the city is looking at that in terms of the consequence of 65.5 is that if someone came in and tried to build an ADU or try to get a permit to build an ADU, they would be denied. And they have been, at least one person has attempted, I think, and they were denied. So currently the city is interpreting land uses to be accessory as well. Charter establishes the framework of governance, while detailed land use regulation is adopted by ordinance. Clarification is needed on how 65.5 is intended to interact with council's ongoing authority over the ULUC and charter provisions requiring property restrictions to be enacted by ordinance. True, there is a little bit of challenge with having a zoning restriction within your city charter. There was the ability to have actually adopted 65.5 by way of ordinance, which would have prohibited council from making a change to it. But, I think it's fair to say that 65.5 for our council, or for most likely any council, having that provision in there is a challenge for being able to enact zoning and land use changes. Notice additional clarity around what constitutes a comprehensive rezoning or text change. How the preserved right of property owners to seek rezoning should be implemented with improved predictability. So comprehensive rezoning is set forth in our city code. It was actually never part of our code before. Other cities have the ability to take large areas of property and rezone them on their own accord. That was never anything that the city of Littleton had. So I actually put the provision in when we adopted the ULUC. And that was specifically because we were changing all of our zoning districts. We were getting rid of the R1s and the R3s and the R5s, and we were going to the SLRs, MLRs, LLRs. But I did put some guardrails on it so the city could not come in and, rezone your property. Would need to be at least 40 properties. So it had to be a broad swath. So in terms of how comprehensive rezoning fits in with charter amendment, I think to an earlier comment that it's a little ambiguous in terms of what land uses are. I think the third sentence in the charter provision, which talks about city council being allowed to quote unquote comprehensively rezone, because no one else could comprehensively rezone, provided they have given first class notification to property owners, is some ambiguity that currently exists within the code. And it invites the question, can city council still rezone? Could city council decide, you know what? We took duplexes off because it was controversial. We didn't have a good vetting process. There wasn't enough communication. Let's restart that communication and let's see how, get rid of multiplexes. That was too controversial. People thought multiplexes were something different than what they were. But what about duplexes? Duplexes, in theory, depending on your reading of the city charter, so long as they are providing first class notification to all affected property owners, an argument could be made that they could comprehensively rezone. So we would have another ordinance saying duplexes are great, so long as they mail it out to everyone. An interpretation that still exists. So there is some ambiguity. Is that what the drafters intended? Probably not. I don't know. I think the intention has kind of perhaps changed depending on who you talk to and how the public messaging evolved. From when it was first brought to the city's attention to perhaps how it was messaged towards the end. How a voter would have read this, I don't know. They could have looked at it two ways. They could have looked at it like, you know, when I talked with RIL representatives, or what they say is, we never wanted this to apply to ADUs. We're totally fine with ADUs. We don't care. Maybe. There has been previous messaging by some that were in support of 65.5 that they didn't want ADUs either. To heck with the state. So how does a voter read 65.5 and why did they vote yes? Why did they vote no? I don't know. I mean, that requires, I'm sure people had different opinions as to what it actually meant. I don't know. I just want to stop me and throw questions at me.
Well, I think it's important to kind of get through these, but, I mean, is there a broader statement about this section that we can make, or do you want to go through them one by one?
Well, you know, if,
I have in regards to the home rule
yeah,
provision. Does Littleton being under a home rule provision, does that mean that they're not they're not in violation of the new state ADU law that passed?
it's a great question. That has been the argument that has been going on. So for, I don't know, 100 years, courts in the state have deferred to local jurisdictions, home rule jurisdictions, to enact their own zoning and land use and planning. They have considered that to be matters of quote unquote local concern, which gives us the authority as a home rule municipality to enact our own laws, our own ordinances, as well as zoning and land use planning. What has happened over the past few years have been attempts by the state, by way of legislation, to basically get involved with housing specifically, saying housing is no longer a matter of local concern. It's a matter of state concern, that folks can't live anywhere in the state. Affordability is an issue, and they have specifically set forward that it is a matter of statewide concern. When things are matters of statewide concern, they can trump home rule municipalities. It's when it is matters of local concern in which we have full authority over what we're doing. So that has been the attempt, which they have been largely successful in doing over the last few years, including mandating certain requirements. So there are jurisdictions that have sued the state trying to get clarification, not really clarification. They're trying to get a court to say the state does not have any authority over how we zone or rezone or upzone our properties.
So those are ongoing.
I think there might be 6, there could be 7 now. That is in the court. It's been briefed, to my understanding, and talking with one of the attorneys, for probably 4 months. It's been sitting with the court, waiting for the court to make a. Now, it's not specific to ADUs. What they challenged were some other provision, other state requirements on, I don't know.
Transit-oriented development.
Yeah, there was stuff, parking and, basically
Parking requirements and density
density,
around transit.
correct.
Those were 2.
But it's the same question.
Sure.
And so we're waiting for the court to make a
Determination.
decision on that.
You say it's 4 months out?
It's been with them for 4 months. It could be any day. I don't know. They're not.
Okay, it's been, they've had it in their hands for 4 months, since last October.
That's right.
As soon as the Democratic primary happens, you'll see some.
That's a good question. This is
intellectually interesting. However, this is an amendment that just was passed by voters. Just remembering our purpose here, like, we're supposed to be making recommendation to council, like, I doubt we're gonna go to council, that's just my guess, and say, look at this, because I think they're already looking at it, aren't they? Like, do we need to spend a lot of time on this in this room? Because this just passed by voters. I got to imagine that they're not gonna put it on an amendment to repeal it next year. And if they do, they would do that through the political process anyway. So my point here, in just this group, is this worth looking at?
I would agree with you, Dan.
Thank you for that, Dan.
I'm in agreement.
I like the intellectual conversation. It's fascinating, but it just isn't really our purpose.
I think that's beyond what we need to be doing today.
I would argue if we're here to make sure the machine is working and somebody just threw a monkey wrench into the machine, it's also in our best interest to say, hey, maybe we should get this monkey wrench out of here because it's untenable and is messing up the machine.
Well, and I think what I would say to that, just from, I did actually listen, I wasn't here last meeting, but I listened to the recording. And Colleen said that we're not recommending language. We're recommending, so it's fine if we want to say,
Take a
look at this.
And we have done that with all of these questions,
Well,
right?
and I know that, didn't they go into executive session this week to go review this all? So I think it is already there, and I'm fine to do that, Billy, to put, let's review this. I'm not sure we need to come back with specific recommendations.
Well,
Right.
it carries weight, I think, if a board committee made up of citizens says, we see problems, we think there are changes needed, we do not think this is sustainable in the long term, versus the perception that city council is doing it on their own. I mean, that's why we have planning commission say, planning commission thinks we should do this. The transportation mobility board says, we think that council should do this.
And I would say that when in reading all through this, anything that was passed by voters in this charter, it's like, this is a mess, review it. Like, it's not written by lawyers or political process. And so when I read the whole one on urban renewal, that's also, I'd say, review this. But I'd say that this seems to be, they set us up for a mess here.
I think it brings up the issue that, what that's highlighting is that it's too easy to change the charter because we have no rules on it. Our charter doesn't have any protections against citizens making rules. It just defaults to state. It's actually a simpler process to change our entire charter than it is to add an ordinance.
Yeah.
And
That's
so
backwards.
that's backwards. And so that's what I think we should probably address because of 65.5 is that we got to fix that. We have to put something in there, and this is how Littleton amends a charter. It's more in line with the recall petitions, it's more in line with how you get onto the ballot. It's more in line with how you get an ordinance in place. Because right now it is the simplest path to just put any gobbledygook onto a piece of paper, get a smaller number of signatures, and then it's on the ballot to change your entire charter. So I think that's what we should talk about as the review committee.
Well, we already said that we would.
Yeah, and we do have that on board.
I was just going to say, like, if we are all in agreement and have consensus that council is already looking at this and we think that they should look at it, I think we should move on at the experience of time and discuss other areas that may be a little bit more, or, they may need a little bit more input. Because again, we had this discussion for 6-7 months last year. Yes, I
To Billy's point, I'm fine with saying something like, we believe that it needs to be reviewed.
Yeah.
But I mean, is that gonna be the level of our recommendations? Is like, you should look at section 128.
Yeah, could we perhaps, I think a lot of the questions that we received from you, Colleen, as you compiled everybody's questions, were surrounding definitions, right? Who is an affected property owner, land use, those kind of things.
And
So
a lot of that is addressed either in statute or in our code.
right, but could that be the recommendation perhaps to council of we need clearer definitions of what these things are, whether it be through ordinance or other, Reed's interpretation.
But how would that?
Are we just gonna sit on our hands and wait until we get the pantsuit off of us? I don't know.
I don't know how that impacts the charter. I mean, it's kind of what you're talking about. It's a great discussion. And the definitions need to be fleshed out.
Yeah.
But there's not a recommendation for charter.
The recommendation is to define the things in this ordinance or in this amendment.
So are you saying add definitions to the charter?
Yeah, I think you have to in order to figure out what this thing is trying to say.
I'd like to make a comment. From my perception, these people are the senior staff, along with the city manager. And the council already knows that they want to do something or they're reviewing. We should just let them do what they do. And we don't need to get into the nitty gritty about definitions or any of this other stuff. And I think that we should move on to what our real challenge is, not 3A.
Well, I mean, could we say that? I mean, we could say that about the whole charter, like, city
I
council
didn't
can do
say
whatever
that.
they.
I
know
said
you did.
specifically about this.
I normally try to remain really neutral in this, but, I think that that's an unfair comment. Because when we started this section was not in the charter. We didn't know if it was gonna be in the charter. And so what we were tasked with was reviewing the charter as it existed at that time. And I think that there has been a lot of time and energy put in on this specific item in conversations that are already being had with the legal team, city manager's office, and other experts. And so to say that if we're not going to invest that level of time and energy on this section, we should just throw out everything, I think is a little bit unfair.
So I would,
Excuse myself.
I would say this, I believe that council is curious as to what the Charter Review Committee's recommendations would be on 65.5. If there were going to be any changes, future changes to 65.5, I think, I don't know how I say this without it sounding like some nefarious plan or anything. It sounds better for a city to try to pursue those plans if a citizens group has recommended changing the charter rather than the charter review
Doing it on
committee
it.
said, oh, it's totally great. I mean, and if that's the case, that's fine. Because that could be used in messaging if this actually went forward, but does that make sense?
Yes.
I mean,
I just think our recommendation should be a little more fleshed out than like, you should look at this.
Right, we're just flagging it.
Because that seems like where we landed.
Well, Well, I think that we have included, I think we have included enough question that could be passed to council. You know, as a recommendation, say like, hey, look at this, these are all of the questions that we had about it, you know, because we are confused, right? We need, and it will be helpful to flesh it out. But I'm in agreement that we also need to move from this because.
Well, and we're not gonna get the answer tonight,
Correct.
right? And
Right.
so if we provide this document with all of the questions and the thoughts that you all have taken time to flesh out on your own and submit, council can review those. And even without a recommendation from this committee, can say, hey,
They can
this
take it
is
on their
something
own.
real, we can put something on the ballot, even without a recommendation.
I have a follow-up question. During the pre-election cycle, there was a lot of talk about like, from the proponent side of this ordinance. We're using this as a 2-year pause. There's no sunset clause that actually reflects that. Is there something in the charter that reflects that? Like an ordinance can't be repealed within 2 years. Is there any idea of where that came
If
from?
it is passed as part of a special election, this was not a special election. This was done as a regular election.
Okay, so special elections
So that
have a
2-year
2-year.
timeframe does not.
Okay. So for science theory, council could choose to amend or adjust this based off of any
They
recommendation.
choose to ask voters to.
Yeah, sure. Yeah, they can't do it themselves, but they could put
Yes,
on their own something on
Another
the
citizen.
ballot.
or an,
Another citizen.
and we don't, there's not a 24-month.
You asked a question for us individually to submit to you questions or thoughts.
And
Five people.
that's-
5 people did
That's
that,
what all this is.
right? 5 people did that. That could be transmitted to the council as these were the comments that were made by some people at your request.
Right, and that's the intent is if we move on from this section, and I didn't mean to offend in any way, just, this would be submitted to them along with the actual suggestions. There might be a note next to it, next to 65.5 that says much discussion and concerns, see attached, right? So that they have it and they can do what they will with it.
Right.
Right, because I can guarantee, that they have in part or in total as a council or individual members all asked these questions and talked about these concerns internally amongst each other with staff. So this isn't anything new.
I think it would be nice if we put a note on there that as a committee, we could spend the entire
Yeah.
4 or 5 months discussing this. And we know it's a topic for them, and we're gonna pass and give them
That's
some
fine.
input.
That's fine.
Do we have consensus on that?
Is everybody in agreement to move on from this item note and continue with the other? Okay,
Let me get the other document back up.
and we only have a few sections, correct, that have, we have raised comments in the past. so-
Correct. So if we move on, section 67, cooperative contracts, does this need to be included in the charter? Is there value in asking our citizens to remove it? Is it eating any hay if we leave it there? Does it cause any issues?
In general, I like the idea of removing things that don't need to be there. That's just my thing, right? I mean, when the document is full of so many things that aren't causing any problems but don't mean anything,
Okay.
it dilutes it. So, and we're seeing a lot of that with just like the outdated technology being explicitly called out and stuff like that. So it was my take. I'm not gonna argue
Can I?
on this hill, but
Can I offer a counterpoint? Not that this is tennis, but as somebody who does work with cooperative contracts, there are a lot of counties or special districts who are like, well, it's not in our charter or whatever. We don't know how to handle this, so we're just gonna be hands off. Where cooperative purchasing contracts can be a real benefit to public entities like schools, cities. Like it's a publicly bid award through whatever public entity, and you give like special discounted rates. So I think that having this in here kind of erases that.
Excuse.
Well, I mean, maybe not an excuse, but
Or the like,
if
we
someone-
don't know.
if a citizen were to say, why are you entering into, what authority do you have to enter into a cooperative agreement with someone in another state, which we have recently done?
Uh-huh,
We could say, it's in our charter.
yeah, and it's already been publicly bid.
And amended. That's what's trying to
Yeah.
do.
Yeah, but I think that was just
Fair
language.
enough, Tamsin. I'm just making a general comment about, it seems like there's a lot of stuff.
Okay,
I mean, I'm not gonna die on this hill, just from a professional standpoint, I think it's a benefit.
and Phil, to your point, I think if we look at what the first charter review committee did, they made 30 recommendations. Only 10 made it to a ballot. So.
Yeah, but if it failed in the past, doesn't mean it fails in the future.
The only recommendation for removing 67 and probably 68 below it is like, well, we can just assume that we'll just retain those powers. We don't need to explicitly spell them out. And the argument against is, well, it's helpful to explicitly spell them out sometimes.
Yeah.
Okay, so can we get a consensus on members who may want to recommend removal?
Of
May I
67.
ask a question? With the trash service that's coming up, where we're going in with other entities, would that
Potentially.
potentially? fall under that? Like, is that an example of
Oh, yeah.
a use, I guess?
Potentially.
Are you asking about 67?
It may
Yes, I am
not.
asking about 60.
It may not, though. Interagency agreements aren't necessarily cooperative agreements.
Yeah.
I mean, they are cooperative, but they don't fall
But
under.
they don't fall under
Yeah.
cooperative.
So in the event that this isn't in the charter, is it done by staff?
It wouldn't change anything we do, whether this is in the charter or not.
Okay.
Mhm.
Okay.
It just gives them, somebody were to come and
Fuss
say,
about it.
and I'm gonna sue you because you don't have this power. Even though it probably wouldn't be the process to sue you away.
Kansas changed my mind on this.
Okay.
Okay, so
I can feel it.
Does anybody want
does
to?
anyone want to recommend removal?
Recommend for
or
removal.
Are we fine leaving it? Okay, same with 68. Reed, is there a benefit?
It doesn't, there's a whole ethics section in state law that talks about how to.
How to do this?
Yeah, that's fine.
Okay. So I'm going to move right here. Seconds, please. We are not recommending doing any of these sections.
If we were drafting a new charter, Phil, I would be so in your corner, man.
Oh, yeah.
Let's go with the stuff, clarity and emphasis on what matters. We don't have that luxury, so.
Okay, so now we come to, removing reference to at least 3 column inches in size when it comes to, public notice.
Isn't that an
I think it's
old
relevant.
newspaper
Probably
term?
not relevant, but I'm also wondering if there's a way that we can do it as like a text change throughout. Like a
Modernization.
modernization change of some kind throughout the whole thing.
But how many times does this appear in there?
Well, there's
Well-
several references to different amounts of sizes in.
Modern
public
technology
records.
changes.
Yeah,
So something we can think about. I can go through and compile all the sections that reference, like legal notices.
Or just old technology,
I just,
removal of old.
I understand that there's
technology.
like several steps to get it to actually be changed. But if our intention is to
Clean it up.
clean up our charter, I feel like we're often not doing that, but I just.
Yeah, but if we recommend removing all the references to technology and it never makes it to the ballot. So be it.
But I think you have to be a little bit more specific than just all references to technology.
Well, fair-
I
well,
think-
fair
Just
enough.
like,
Yeah.
Because the
we have
ordinance,
to update the specifications on notifications, I think is kind of.
well, and I think we need to avoid the specifications for size because that
Yeah.
really is,
Cause like 10 years ago, it could have been like, it has to be published on Littleton Gov's blog, and like, are we gonna do that?
Must be on MySpace.
Yeah.
It's supposed to be on MySpace, so like, do we?
you can only do it if you have an AOL email address.
For what it's worth, our finance director would recommend taking out the 3-inch size, so it'd be
Okay,
notice of such hearing shall, whatever, be published at least 1 week in advance of the hearing.
yeah, cause published, I
Just
think.
strike out shall be at least 3 inches. She also has some other recommendations, which didn't make our charter review committee.
Still time.
Let me ask a general question here. I'm not disagreeing with the concept. But the issue is that we then have, should the council say yes to a big slew of these, then it has to go to the citizenry. And they have to understand it.
Right,
And
it's,
it's gonna be very complicated to make the citizenry understand the changes.
some of them yes, some of them no. And so,
I mean, in general.
right, and so one thing that I have talked about before, and I have talked about kind of that lead time for education and community outreach. Anything that we put forward to council in April when we meet with them, they may take a look at it and they may take some of that low hanging fruit that, some of these things, right? Like a global update to the charter to take out references to outdated technology, those things. That's a pretty easy thing if they decide to move with it, to put it on a November ballot. Doesn't take a lot of education. There are going to be some pieces that would be a heavier lift. The chances of them wanting to put that on a 2026 ballot, pretty slim, right? That's something that they might look at for next year so that we can engage our communications team for that public outreach, engagement, communication, things like that. So I don't want anyone to be thinking that anything that we sent, just 1 second, John, anything we sent forward to council is, if they decide it's worth putting on a ballot, not everything's going on this year. Okay? Does that address your?
No, that answers, that's where I am.
Okay, okay.
Does each individual section change? So we recommend wording changes in section 74. Do they each get their own, or does it go as
So
a?
if we do a cleanup ordinance, the question would be drafted in such a way, right? And it would be drafted by ordinance that should the city charter sections, you know, whatever they are, be a list, be changed to remove references to
Column width.
outdated technology and column width. And then in that ordinance, Reed would have each section and he would have it redlined.
Okay.
So that it would,
So it could be referenced.
yes, they would be able to see what's being
Change.
removed, right?
One vote.
It's one vote on multiples. We did that the last time where we went in and changed, you know, gender reference and, things like that. So, and that was kind of a catch-all.
Okay, thank you.
And so, yeah, it would not be multiple questions. Okay,
Okay.
we good?
Yes.
Okay. So additional appropriations. Reed, do you want to address this one? Is the figure for temporary loans and the 2 mil levy cap on assessed valuation still appropriate, or should it be raised?
Remind me, Colleen, is this the only section that talks about how much money council can borrow?
Pretty sure this is the budget.
Yeah,
So this is the one that reduces the amount that we can borrow in comparison to state law.
Like significantly.
Correct.
Yeah.
Yeah, this one's an easy one for me.
What we've heard from staff is the problem.
Yeah, this is an easy one for me. I mean,
so is there consensus to move this forward to council for consideration?
Yeah, 100%.
Anyone have an issue again?
In my notes, and I can't recall the conversation I have, in what period of time, there's no time limit.
That's what I was gonna ask, the payback, the payback, is there, I have no problem raising it or suggesting to raise it, but having a payback, a timeline payback in on it.
So if whatever the cap is in the charter, the city would have to ask voters to approve it. And when we ask voters to approve it, that's when we would describe the terms that we're looking at.
Okay, thank you.
So in the end, moving the cap here doesn't reduce the fact that we still have to go to voters. And show all of the details of the law. So to me, it's actually, as someone who lives here and as a voter here, you know, I want the chance to be able to weigh in, and right now, our charter doesn't give me that chance.
Because we can't even ask for more.
We can't ask for more, exactly. So I think voters deserve the right to be able to weigh in.
Are mill levy caps even the appropriate,
If you match it to the state, that is what the state does too. Yeah.
I said, no, it should be like last year's budget or the total GDP of Littleton.
So if you didn't match the state will limit us anyways.
Okay, so we will move forward with that. Thank you. On powers and duties of finance director, and this is publication requirements. Is this one of the areas that Lori wanted cleaned up, Reed? So section J that we're speaking to, Submit to council through the city manager a monthly report of all accounts of funds, including trust and custodial funds. I don't know what that cleanup would look like in section J. I do know that it speaks to the finance director preparing a list of all employees. That does not come from the finance director, that comes from HR. But when this was written, the finance director was HR, so.
At 500, I had in my notes, the $500, everything above $500. Was that something, I thought that was something that we had talked about raising that threshold to be whatever, I mean, $1,000 or $5,000. I think $500 is a.
Really easy spend.
So what-
Yeah.
Really low.
So
It also
what
has to be in a
I- what I
legal
view as
newspaper.
There might be appetite to delve into this section more and discuss the recommendations to council. Can we just leave it as a yes or
That's fine,
no
yeah.
and look at?
$500 in 1979 is $2,300 today.
Okay.
So just a little bit of a
Yeah.
dip.
Mhm.
So.
And then it does have some references to publishing things.
Yes, it does.
So we fall into that for
Yeah.
potential.
So, and I know that we put subsection J, but I think maybe if we kind of look through this whole thing.
So in terms of section J, if you want to scroll down, I think what was most problematic is it's in the middle of that. So basically where you're. Make such report available to the public inspection it is, and have published monthly all disbursements of $500 over in a legal newspaper. So it wasn't really the amount, we still do the amount, it's just, we don't publish it in a newspaper. So the city is not in compliance with the city charter, we have it online. And we're happy to do that, but in terms of if we were for recommendation for finance, we shall publish it on this website or other.
On city's communication.
So Mike, how is this working today?
What we just said.
It gets published on the city's website.
So we're not in strict compliance. So like Carol has made it clear that she feels that she'd love to have a charter that we can strictly comply with. So if you want us to be able to be in strict compliance here, recommending a change probably makes sense.
To me, this fits in the general comment.
That fits in the.
Yeah, it's just take out the
Yeah.
newspaper requirement and move on. Yeah.
Not all people, but how
Just change it to public.
change their.
Yeah, just change it to be published and leave out.
Yeah.
The medium.
Well, and because the council does pass as the first resolution of every year, where legal notices and postings of meetings are to be posted.
Yeah.
And
It can be in
so
like.
it does say the city's website, 3 physical locations, and a newspaper of general distribution when required by statute or our code.
That's generally how the federal government handles it, because there's certain
And
things.
so
that-
I think, yes, if we take out just newspaper and just say published, this could be part of that general cleanup.
Yeah.
Okay,
And then whatever annual publishing. entities we align with.
Okay.
And our goal really is to be the face of our community. So
Right.
if there's something new that comes up that better communicates, we'll want to use.
you and the TikTok.
I've never. So. All right.
Sure.
Did you have something else on that section?
No, but I feel as if I'd be remiss if I did not bring up a couple sections that were. I don't know how you want to.
Can we get through the rest of them first and then come back to it? Or do you want to go back to them now?
No, I just dealt with finance and.
Okay, well, let's go back to them now. Which sections are you thinking?
Well, it's not on there, but I don't know if you have an ability to bring it up.
Which-
These are just 2 comments that were made by our finance director, which she finds problematic.
Okay, what are the sections?
She didn't give it to me in time for our meeting when we talked about this section. But it was section 70. And section 76.
Section 7.
And I'll throw it out there for the group.
Submission of the budget.
It's submission of the budget. It's not later than September 15th of each year. And then Section 76 also talks about not later than October 16th. I think it's those dates that have been at least recommended by staff. They don't need to be in there. So September 15th of each year. Apparently, depending on the year and what's going on, that might be too early. And we have to submit to the county our mill levy by December 15th. So that's really the date that we work with, needing to get that. So September 15th and the October, not later than October 16th, we introduce a tax levy ordinance. Both of those, I guess, are challenging for our finance department and are somewhat kind of an arbitrary date that are not necessary. So I'll just throw it out there. I don't know. It's unfair for you all to discuss it or really put much thought into it, but it was just, they weren't necessary dates. And so.
Yeah.
So the key date is.
Key date is what the
15th of
date.
December.
Yeah.
Yeah, I mean, I like the idea of more flexibility rather than less, since it will still have to happen either way. Just to give an example, right, all the special districts in Colorado had a lot of problems in 2024 when the state legislature passed the mill levy assessment rate reduction, and it screwed everybody's budget up, and then everybody had like barely got their budgets done in time for the December 15th mill levy. Yeah, I mean, there's things out of our control that could change our ability to, publish a budget when we normally want to.
So the recommendation, would the recommendation be to take the date out?
Take the date out.
Just take the date out because the superseding date is the 31st of December.
15th of December.
15th.
Yeah, and so they kind of work back from that date.
I
support that.
I support the removal.
Yeah.
Dates, yeah, if it gives them more
In
flexibility.
both sections, 70 and 76.
Yeah, I mean, I don't think it's.
Anyone not support?
What does the date in 76 mean? So like, it says no later than October 15th, council shall introduce a tax levy ordinance. Are they introducing it to whom? Is it, like, is this presumably something to be voted on then, or what are they?
On which one? I'm sorry.
76.
76, I'm just wondering.
Council has to introduce an ordinance at first and second reading at
Yeah.
council.
Yeah, they vote on it. We don't.
Should we go for a
Yeah, of the existing mills.
Yeah.
Right. This is like a new tax, yep.
so that the public has some idea
Expectation.
that the budget would be published in this, between September 1 and October 30 or whatever it might be, rather than no date in there at all.
Right, and then suddenly you have an ordinance that just appeared adopting a budget that.
Well,
I'm not,
I'd like to know
Makes
that there's
sense to
gonna be an annual budget.
The city council have to do the first and second reading by December 15th.
we do an emergency order.
Love it.
I mean, I think it's, if there was enough agreements or concurrence, we could simply put a note that may need to look at those dates, but provide
Ask her for
some.
her suggestion.
Sure. Her suggestions were just to remove that, but I can certainly appreciate it if you actually want to look at it.
And then we can come back at our March meeting, when we go through everything that says yes or maybe, and kind of plug in, think of some of that stuff. So Reed, do you want to talk to Lori or do you want me to ask Lori?
I can talk to one.
Thank you.
Sorry.
I think the spirit behind having that in the charter was to ensure transparency of budget for the community. And it's one of the most transparent things we do. I mean, there's multiple meetings throughout, basically, we're in an never-ending budget preparation cycle. And there's multiple meetings, and then we legally have to do the public hearings, which, two different.
It's to show a finalized budget before.
But even in the preparatory stage, it's very transparent. I mean, so citizens that want to know how this is going, have a chance to weigh in and say, no, we think there should be more investment in this or that. I mean,
Even the council's budget workshop where we're all together, it's open to the public.
it's hard for me to imagine a council ever wanting to reduce transparency when it comes to the budget process. It's one of it is the most important thing to do, period, is adopting a budget this year.
But it would be great not to have it due a whole
Yeah,
quarter
the-
before it
Right.
legally
Yeah.
And I
by
think
state
that's the
laws.
challenge, because we're actually, based on the timeline, once you start backing it out, it's like, we're doing this work in like June, and half the year has gone by, and we don't know what's gonna happen in the latter half, so. Like my finance director.
Oh, keep it on, man. You're doing great.
Okay, GO bonds. You want to read the question and move on to that, please? It's a lot of words.
This is what we were talking about earlier.
Right.
Two sentences?
That's really long.
No, we've got
At least four.
There's
Yeah, there's a lot of questions.
It's a lot.
The general obligation debt ceiling for the city to its economic capacity and revenue projections, where there could be debt payments. There's limited capacity to pay debt. Many circumstances or significant questionable project or obligations. Is there a debt service level and the percentage of general revenue that should be looked at? Should a more complex and flexible formula be prepared and used to basically cover information about balanced debt portfolio for the various enterprise funds, with specific uses and payment structures? Discussion that existing language is too prescriptive, recommended change. So,
Let me make it, can I make a comment? I wrote this. I had talked to Steve Barr previously on council. This was an issue that he brought up to me that he thought was important that the Charter Review Committee could look at, or the city administration needed to look at, because it was out of line with what is possible today. So that's why I wrote what I did, trying to do a Vulcan brain meld with Steve Barr about this issue. So that's why I wrote this. And so I leave it to what it is, should something be done. And my sense was that the staff had thought that this was an area that, and I would ask you if that's true. John?
Is this where the limit was?
3 7/10%.
It does say that isn't it?
Yeah.
So yeah, this is the key one, not the other one then. Yeah.
Yeah, this is the one.
Yeah.
So I have my notes that the 3 7/10% works out to $49 million today. And that the standard used by other cities, or the recommendation was to move that to 10%, which would be $132 million today.
And really, you know, I think it behooves us as residents to have the city have tools in their tool belt. And this does not allow them to use them without voter approval, but it just says, hey, if you think this is good and you want to propose to voters, you have that right. And we can't go higher than the state limit. And so matching it makes sense. We may never ask for that amount, you know. Right now we have zero. We have zero. And so, but I think there's a real good case to be made for it from an equity perspective, especially. You know, I used to have a neighbor who said, yeah, I love debt because I don't even buy green bananas anymore. I don't want to pay it all on me. I want people who are here 10 years from now, 15 years from now, 20 years to pay their share, you know? And so allowing the city to have the debt capacity makes sense, which is what we covered before, so.
And I think, to Ken's earlier point too, this would be one of those things that should council decide to take some kind of action on, would not be a 2026 question.
Oh, no.
Because this is one of those things that is.
It's a lot of thought and more vetting.
I think
Discussion.
for me, it's a yes as well. So.
that's easy.
Can we go ahead and just,
We can move.
agree with this?
Love it.
Thank you.
And I wouldn't say it's not necessarily a 2026 question. They were kind of interested in this last year and the year before, so.
Yeah,
Well,
It may not,
yeah.
I'm just saying that.
Regardless, though,
Communications.
Having this weigh in would be helpful.
Regardless, though, what year it's on is not up to us, so.
Yeah.
Okay.
Special or local improvement district bonds issuance, does this conflict with state law?
Just in general.
I'm asking the lawyer.
It's been a while since I've looked at SIDs, SIDs, it's, I don't know the answer, but I'll find out
Do you
shortly.
want to put this as a maybe and come back to it?
Yeah, that's fine.
Well,
Pending legal opinion.
Yeah.
yeah,
Pending legal.
yep. Special surplus and deficiency fund, how is this fixed by council? Does this need to be included in the charter?
When it says amended section of 98, does that mean that this specific section was changed?
Something in the section.
Do we have any special districts that were established before 1999?
That are active. That are still active.
Because none of this applies to anything after January 9th.
Colleen,
I don't know what the district
in the
is.
notes from the last group that did this, they struck this whole section.
Yeah, but I don't know, I don't
It did
think
not
this,
go.
it didn't go to the ballot.
No.
No, it didn't go to the ballot,
Yeah,
but
they
I'm
made a
just, I'm
recommendation.
offering that as evidence. This is now what we've discussed, but I'm looking back at the last one and this whole section, they struck that one, they struck the next section. I'm not saying that that's right, it just is. This group of us,
That was the previous record,
of citizens looked at that and
10 years ago.
I mean, and the other thing is, there's a whole thing here, there's some really good information that a bond council gave advice to, so. On any of these, I'm just wondering if we're handing it to council, if you wanna say. Or what the previous group said,
Well, I mean, I think this is a different council too, right? And so if this was recommended the last time and you feel strongly about it, recommending it again this time, there's nothing that would preclude us from doing that.
I mean, it's legitimately out of date, right?
If there are no more
If there-
special improvement districts that are still active.
Yeah,
yes.
like,
We have,
don't, what is that, right? Cause I'm thinking of like a metro district or a tax, what's the tax increment financing? What's that called?
Yeah, for DDAs and urban renewal area.
Right. So, yeah.
So
because if there aren't any special districts that were formed before 1999. Fair point. I think we could do that list to be removed and let council decide. But then-
Would it have impact on any future special?
no.
Well,
Areas.
special districts is a very well-defined term in Colorado law, but I don't think that's what this is referring to.
I think the answer is no, because it says none of this applies to anything after January 99.
But it says unless the ordinance authorizing the issuance of the bond provides that this section shall apply.
Contradicting itself.
There's.
There's a loophole.
Wait, scroll down. It's up.
Could we put this on the burner and like the meeting
That's
and
the
have
legal
report
counsel.
back?
No, like, I think the spirit
So-
makes sense there. It's just not, like, the way it's written is not immediately relevant.
Generally, anything before 1999 is fine, unless we need it, then we're gonna pull it.
So real world scenario. We had a metro district that paid off its debt, River Point or and there was an amount which they decided to come to city council and bring checks, which
I still
I
have,
cried out of Jim's hands and I gave them a call and said, oh,
I mean, relatively nominal, but it was amounts that remained from their collection of property tax or ad valorem tax. If we put it in a special fund, it's on the retirement fund, offered desk. But it seems odd that we would establish a fund to help out a different district that may be struggling. I use that term to pay off their own debts. I don't know.
Do you want to do some research on that, Reed?
I will.
The previous one, the recommendation was section 93 could be repealed as an obsolete provision if the city has no special assessment bonds outstanding, and it does not.
Right.
So to me, I think
Research done.
we can say research that, and a good
Yes.
group of citizens have recommended that it's an obsolete piece. Now, again, I can imagine voters trying to read this thing and get this.
What on earth?
So are we a maybe or are we a yes?
Yes, I mean.
I don't know.
I'm Team Dan on this one.
Throw it away.
You're also team 2015.
Do we see the thumbs on including this? Striking this.
Okay.
Including the recommendation.
Yes.
Right.
Motion to strike, yes.
Thank you. Another thing. Oh, boy.
Section 100 and 103 are completely redundant. But again, doesn't gain us a lot of things. 103 has the word term limits in it. That's the only difference.
Capital.
I think we talked about,
But they both say to award capital improvement projects.
I'll just put a note in there.
yeah, that's.
For now. Okay.
Yeah, what a terrible question.
No,
So I see Mike shaking his head.
no. So this was recommended to the ballot. And failed. Yeah, the volunteer fire department. With a little wagon and a Dalmatian.
Curious George, just for
So
fun.
could we rewrite the ballot question to say, because we have South Metro Fire District, and this is completely redundant and useless and has not been in effect for decades. We recommend-
That's leading.
That would not. Yeah, I mean, that's, you know,
A little leading.
Yes, we can create education that helps.
we can create
And we
education.
did not have South Metro Fire when this was, we voted on before, so it is a
Right.
different scenario.
And
We did have a professional fire.
Yeah, we did, but we didn't have a volunteer.
Right, and that's why.
So,
The nostalgia,
Voted against
this is
this.
nostalgia,
Yeah.
Right.
section of the,
yeah. But the ballot question really has to be single issue.
Right.
And so the ordinance to put it on the ballot could have that background and we could do some education. But we also have to remember that so the ordinance for first and second reading that would flesh out all of that, most voters, unless they are pulling down council packets, coming to meetings, they aren't going to see that. Right? They're gonna wait until they get their ballots.
Yeah.
And that's what they're gonna see. But what that ordinance does for us is if that question passes, we already have that framework to now go in, add that section, delete that section, amend that section, and we already have the verbiage.
I think I'm actually confused as to the wording regarding health services in the ballot question from 11 years ago. And it does, the charter does say, for so long as it deems necessary, provide for the formation and operation of a volunteer fire department. So it's like clarifying itself.
Yeah, and we don't deem it necessary,
And we no
so,
longer deem it necessary.
Yeah.
so there's nothing that says we have to do it. So I guess this
So
is
it's,
one of those
it's
sections.
not one of the ones that's like blatantly Like
In
this isn't,
conflict.
yeah.
There's an out, there's an out. So it's one of those ones to me, is it eating any hay if we do nothing with it?
In the first sentence, it includes fire. Council shall provide by ordinance fire, which they don't do anymore.
With
And
to
South
some degree,
Metro
I think by the agreement with contract with South Metro Fire.
City doesn't have a contract with South Metro.
Do we?
Oh,
Right, South Metro Fire is its own independent government and it's.
Littleton is within their,
Within their service,
Boundary.
yeah.
So it provides services
The
to.
city of Littleton has nothing to do with the implementation, the tax money or planning of the services for South Metro Fire.
so the city didn't have to opt in to
We
South
did.
Metro Fire?
They did, long ago.
So would that then be the ordinance that where they're providing fire police or fire and health
Fair enough.
services?
Yes.
By opting into the district?
I think it should just stay because if there is a situation where you do need a volunteer fire, I know Bessie the cow kicks over a lamb, like, I don't know. Why don't we just leave this in there? It's not hurting anything.
Josh is getting
Nostalgia.
information and a.
Yeah, it's nostalgia. I want to find the pictures of the volunteer fire department, but it also takes care of our fire, police and health services. And so that's succinct and it does it and kind of following all the rules.
Consensus on not touching it?
It seems like splitting hairs.
Yeah,
You got better things to do.
yeah, we have more important sections to recommend, to be honest.
Issues. Still don't know what health services.
I think the money or the amendment of the charter is more important than.
Yeah.
Yeah, the money.
So.
Okay. City-owned utilities. Read. I don't remember.
These questions.
She's she's sharing it too.
This isn't some kind of kamikaze deal here. I
I
don't
don't think
remember
that's
where we fell on it.
Relationship with them was. I defer to Kent back.
Did you hear that, Kent?
Pardon me?
He said he defers to you.
Yeah.
Oh, okay.
Yeah, and obviously with our, I mean, this one is primarily about water, what our relationship is with Denver Water. We don't really have a great, we have a great relationship with Denver Water. I don't mean it that way, but we don't have a representative on Denver Water. Denver Water is its own entity through the city of Denver, and its board members are appointed by the mayor of Denver. We don't have a lot of our own water rights as we sold most of those to the city of Denver back in the 70s. I would say, maybe this was something where Mr. Cernanek wanted to get more involved with Denver Water, but we don't have a lot of authority with Denver Water.
What I hear is that we don't have much that we could even recommend to change here, to change our actual relationship with Denver Water. Am I correct?
Correct.
Yeah. That sounds like what we.
does it say anything to how we manage the water rights we do have or?
So, I don't think there's anything necessarily that's talking about it other than we have the authority to exchange water rights. And we do have some relationships with Inglewood as it relates to water that goes through City Ditch and
Connector districts.
we, no, not really the.
Yeah.
We can trade water rights with them. Part of the challenge with our water rights is they are basically along the South Platte. And getting that water up in elevation, so just, we've talked about Kettering Lake forever. About, gosh, it's just a brown pond of duck goo and species, and what can we do? And, we built a well there, and the well doesn't actually generate enough water to actually deal with evaporation, especially this winter.
Sounds like you need to consult a better geologist.
The city spent a lot of money on said well that did not deliver, the requisite amount.
Heard.
What's being built along Mineral, it's not a pond
That's Gulch.
or a retention pond or something?
By Toll Brothers?
No,
Oh.
Mineral and Highline Canal.
yeah, like if
It's
you're.
Jackass
heading-
Gulch.
Oh, is that what it's called? Like if you're heading east on Mineral from Santa Fe towards.
That's a stormwater project.
That's Stormwater.
A stormwater, okay.
High flood district.
Next to the
Yeah.
I don't think there's any real issues with the section. We do have the ability to trade water rights currently in this, by this provision where we give them a certain amount of acre feet or they give us a certain amount of acre feet, just depending on convenient ease of. No, it's fine. It's not hurting anything.
I vote we leave it, or I motion that we just leave it.
I don't have a strong opinion.
What's the consensus? Well, the thing is, like, we cannot change anything that gives us more power with Denver Water. So to me, it's like,
Silly.
I mean,
if there is something, I'm open to hear it, but
There was a.
They're like God, just like the railroads.
They're key.
They tell you how.
Ditch
Yes.
companies, railroads and water companies, yeah.
The recommendation of the last charter review committee was to just remove the language relating to the physical assets of the sewer system. Allow public works flexibility in disposing of unnecessary, outdated or redundant equipment or other large physical assets. And obviously that wasn't adopted and wasn't put to the ballot, but is that of any concern to us in this current?
If you want us to be strictly adhering to it, but we get rid of stuff when it needs to be disposed of.
So.
It's evident that 10 years ago, it didn't go anywhere.
I
Do
mean,
you
Appetite
sell
to
or
just-
exchange it, or do you just get rid of it?
It depends on what it is. So yes, we sell things, we
Okay.
dispose of them in other ways.
Yeah, I
We
don't-
reuse things.
no, I mean, I could see a SPR, so South Platte. Half by the city of, half by the city of. It is a tremendous wastewater treatment plant, but it also has a tremendous amount of liability associated with it when we start talking about PFAS and other types of regulatory requirements on that. And so I know that there's options. Gosh, do we even want to be part of this? Why don't we sell it, make our own district, let voters decide and wash our hands of it? No pun intended. I don't know, it's like, I would imagine a big question like that should go. You know, do you want to divest ourselves of our interest in water treatment?
And it would go to them because this is in the charter.
That's right. So I'm saying, why would we?
So do I understand that there's no appetite?
So we're not worried
you
about it.
understand, correct?
Okay.
Yes.
Yes, there isn't.
That's right.
If we were ever gonna make a big change, we would put a, we would ask them to change.
Doesn't SPR make us money?
To your network.
Isn't
That-
it
that-
intended to make it or offset the cost?
It's rate stabilization,
Great stabilization.
yes.
Yeah.
We don't have a profit though. Any revenue goes towards stabilizing rates.
Okay, so under city-owned utilities, there was a committee question asking for environmental stewardship board recommendation. The city attorney said that it was not recommended to seek that board's input.
Tell us more.
If you change your mind, let us know. No.
I mean, who else would we have do it?
Well, what would your recommendation be?
Yeah.
I don't understand.
I mean,
Our committee question was just like, should we seek input from that other? Yeah, we didn't have any like, anything in specific. We were like, hey, should we talk to them? Do they have
Right
anything?
now, he delegates that to the professionals responsible and it works perfectly.
Yeah, that's exactly what probably Reed said. Not recommended to see if the
And we're doing some really cool sustainability things, so the ESB would be proud of us.
That's fine.
That's one of the few areas we shine brightly.
Yeah, I don't have any appetite for this one. Does anyone?
Methane capture.
Okay, cool, let's move on.
Like it?
Onward.
Onward.
To staff.
So 109, sale of water or water services. Staff recommended removing the entire section from the charter as it's no longer relevant. Reed, do we want to move? Well, this did go to a ballot and it failed. Is it something we want to try again?
Given the way they used to write charter amendments, I guess you try any of them. It's,
Causing any problems.
It's not causing any problems
That's
to
just
have it
one.
there.
It already failed once and I don't think that. We don't have those. So.
Why does staff want it gone?
Well, it's just
Because
not
it's not
relevant.
It's just not
anymore.
relevant?
Yeah,
I
Same
like
thing
that.
as the fire department.
Okay.
Like, it's not relevant anymore, but.
I think some of these that we're calling not, so look at this foundation of a functioning city. And if we have these things that we could fall back
no,
on,
put it to the ballot.
there are laws that we could fall back on to still remain a functioning city. So I don't see why it makes sense to get rid of
Want
one.
to bring it back.
We severed our tie with.
Yeah, if Denver Water disappeared, if the fire department, all of federal,
We will have to do this either way.
we would have to do this. And so like, why not leave it? Cause all of these are just things that make us a functional city and we should have that to fall back on.
Zombie.
So there was a
Exactly.
committee recommendation here to move definitions to Article 1, Section 7 definitions, because there's a separate section in here for
The term.
the public utility. Do we still have appetite to do that so that all of our definitions are in one place?
Yeah, we already have a definitions, we have a few definition recommendations already, so this will be under that
Yes.
general recommendation, like all definitions should be in the definition section.
Yes.
Just say that to the voters, hey, do you want all definitions to be in the definition section?
Make it
Yes.
It's like an index.
A little bit, right?
Glossary.
Okay, and so now we are on to franchise and public utilities.
Yes, that was amended.
It was already amended once. So I don't know that we need
No,
to.
we did not have it, but
Again, we had another one here, staff recommended removing it, it failed. Read the railroad tracks and crossings, did you have any?
I do have a question, I guess, like since it's semi-relevant to current proposals at the state level. Does it make any change with the
The front
front range
range.
passenger rail?
It could.
Right, like I think it's,
We don't know.
Yeah, and we won't for a while.
so we wouldn't know even at, okay, so
They're not at that stage yet.
so this is unknown.
It's likely they'll go to the ballot in November.
I think that's their intent,
Right.
is to go to the ballot in November.
Yeah, they have a lot of stuff they would do. I mean, if the staff recommendation would be to remove it because we generally, this is kind of like, as I said last time, it's in our city charter and it makes us think that we can actually do this, but
We can't.
we can't do that. FRA is not gonna let us do any of this, that we're not.
All of ours.
Okay.
I can't believe that didn't pass in the previous. What did people say? Were they like?
It's because of the.
I want to have my crossing.
It's because of delete it in their entirety. That phrase makes you feel like you're
Yeah.
losing something.
Yeah,
Instead of saying,
Yeah.
instead of explaining, or, I mean, the communication, right?
When was the,
Given that is no longer relevant, should we?
Once we sunk the railroad or the
Yeah.
railroad got sunk, we have no crossings or anything in which.
what year was the sinking?
There's one crossing I need back.
It was a
That was a
long,
long time ago.
Yeah.
South end of town.
Maybe it was recent.
At Santa Fe.
Oh, yeah.
At
it's
the,
been sunk for my whole life.
Yes.
at the farm, at the horse stable,
Tree farms, yeah.
at the horse stable.
South Amendment.
It's like, what are we gonna tell them to?
Yes. Yes. That one is a yes.
So this is the Charter Review Committee,
Instead of being
replacing the word
periodically,
periodically,
not
not
to
to exceed 10 years.
Oh.
Because right now we
And then to
have.
convene another.
You're talking about.
Oh, no.
I got lost.
No. So
This
is there
last-
appetite to make this
I think
recommendation?
this is
Yes.
very important. It should not exceed 10 years.
I mean, should we recommend 8? So
I
that
was
it
gonna say, like, I would
would
like to drop it, but
Yeah.
I also know that, you know.
Thinking
this
every other
is a
election.
time
Now, you
intensive
also kind of have to think about,
From that.
I mean, you can make whatever recommendation. you
Right.
want. But you know,
If we were really dialed in theory, they would meet and say, we're dialed in, great.
I mean,
They'd
I
satisfy
would
that.
say not to exceed 10 years, because let's say their intent is every other election cycle or every third or whatever it is.
But then there's 3 special elections in those 10 years.
And there's COVID. So
Sure.
like, because our redistricting should have happened with the census 2018, 19, 2020, everything got pushed back 2 to 3 years.
Right.
And so we have to think, now that we've experienced that, we can't say it's never gonna happen again. Right, because whoever thought that would happen, right?
Yeah.
So I think the not to exceed.
That's fine.
Because
10 years is fine.
Yeah, because they can do it in 8 if they want, right? They can do it in 6, they can do it next
That's
year
fine.
if they want.
Isn't 10 years really kind of a standard across the board? I mean, that's what it
Yeah,
looked
I mean,
like.
just.
That was last one was 10 years.
But not just Littleton. I mean, just kind of going down that research hole, it seems like that's kind of a general standard out there,
Yeah.
is 10 years. I think not to exceed makes a lot of sense.
I think so.
Yeah, periodically means different.
It doesn't, yeah.
Every now and
Always
again.
got to.
Yeah, 4 times a year.
The sine wave here or what?
I would like to recommend a process. So we have now the yes, the no's, and the maybe. Would it be possible for us to collect only those? And then,
Well, why do we want to collect the no?
no, only those, the yes and the maybe.
Yes and the maybes, that was my
Correct.
intent.
So like, we delete everything else. And then, yeah, could we, before next meeting, vote on priority? So we can be expedient with that. So, I mean, for example, like, we have some definitions terms, right? But like, I don't think that that's the number one priority that we really need to discuss. But like a ranking system of sorts that allows us to say, hey, 9 of us really want to discuss this maybe or this yes, and a few of us are really concerned about the definition.
So to have that coming into the next meeting.
Correct, so like,
To give us a roadmap on what to.
that's correct, because that way we can be prepared, right? So for example, I'm with Josh, right? I think we really need to talk about whether it is possible to understand what to do with the threshold to change our charter. I think that's just important. If we have any power to do that as a home rule municipality,
We do, I checked, so.
you know, like, I'm with you.
Yeah.
I think but that's just the 2 of us, right?
Yeah.
But maybe there are others.
Well, when you talk about prioritizing, that kind of implies like, are there some we're not gonna get to, or what?
Well,
Why do we need to prioritize them?
Well, when you
I think maybe the first thing we should do is go through and see how many yeses there are, how many maybes.
Yeah, if there's,
And I could be wrong, I don't think we are going to end up with as many as the first charter review committee.
That's
I don't think we're gonna end up with 30. I could be wrong. But I think maybe we prioritize the yeses. And then take.
Is that, those are the ones that everybody,
That the majority.
There was a consensus, there was a
Yeah.
consensus.
And then some of them were maybes depending kind of thing, but they weren't no's. So I think that they need to be included. So here's my question. Cause I really don't wanna do this on the fly from this meeting, and mess something up. if I were to get this to committee members at some time tomorrow, that gives you an entire month, although we'd probably want to have some feedback maybe a week out, so that when we create the agenda, we would have an order of what we're going to discuss. Does that?
And we only
work?
have one more meeting, right?
We only have one more meeting.
Before the rec-
Presentation.
Yeah, because the
Correct.
presentation will be in April. And so does that work for everyone?
Will you have we have maybe 3 items that we would check with.
Yeah,
So that we have that information and can.
we may not have answers on that tomorrow
Okay.
from Lori. But I believe we had those as yeses anyway. He was just gonna check to see if she would be amenable to a range of dates, or no dates at all, right? And so we may not have that information until the next meeting, but I think it's still a yes. So it's gonna show up on your yeses.
Maybe in my mind, but yes, but that's fine.
Okay,
It doesn't have to come tomorrow.
well, my next week is crazy busy, so I'm just.
But I think it's reasonable for you to ask for feedback once that comes out.
Right.
Within a week or 2 weeks at the.
Yeah.
at least.
Well, and that's why I want to give y'all enough opportunity to re-review those sections, kind of thing, and maybe develop. And some sections are gonna be a real easy yes or whatever, but I think there are some sections that may require some broader conversation. You know, we had talked about the whole election section and coming back and having a deeper conversation. And frankly, in a half an hour tonight, we don't have time to do that. And I will be the first one who will say our charter regarding elections is a hot mess. However, I also understand we are living in a very different political climate right now, where talk of changing anything election related can become very polarizing. And I can't believe I'm gonna say this, but my recommendation is maybe we don't even address that. That's just my recommendation.
You can also leave it for council.
Yeah.
If you agree with Colleen's real feeling.
You just want to retire before.
When you send out the homework assignment, it's basically a major homework assignment. The agenda today was a discussion about 3 or 65. You know, so if you've got a homework assignment and you want us to give you feedback, I think that's in the next 2 weeks. I think that's perfectly legitimate.
So I will get this together tomorrow so that we can address those sections. And then, you know, maybe I'll number them. And then y'all can just individually send me, this is the order I would like to address them in. And then what I'll do is I will, much like I do for council with boards and commissions and things like that, is I just do little hash marks.
Okay.
And then whoever gets the, you know, highest number gets moved to the top. And if I have some that are, you know, the same numbers, those I'll put sequentially, right? So,
That's fine.
if that works for everyone.
Give us the rules of the road within the
I'm gonna give
context.
everyone the rules of the road.
Could we,
I'm just gonna let you go road, Kent. Yes.
there are a lot of sections and I mean, if you want to rank all of them, that's okay. But I would recommend, at least what I'm going to do, is to rank the top 10. You know, like, I feel like that's, you can rank all of them, that's fine, you know, holding will send a document, but I feel like if you have a top 10, then that allows us to cross-reference a little faster.
Right, and so
Yeah.
then the other thing that, and I mentioned it at the beginning of the meeting, until we know how many we are going to be having those deeper conversations on, is it possible, or is there an appetite to potentially start the March meeting at 6 instead of 6:30?
I'm okay with that.
To give us an extra 30 minutes. I know we generally don't like to go past 9. 8:30 is kind of our cutoff. And so I think earlier might be better to give us that time.
I like
Our
6.
preference is not to schedule another meeting.
That would be my preference.
I think an extra half hour, if we all do the assignment, we have the priorities, we go through them, and we just say like, you know, we did not get to it in a deeper discussion, but we still think that you should at least take a look at it.
Mhm. And we can capture those sentiments, right?
Right.
Of what the committee feels needs to change. Because again, we aren't looking for verbiage. We aren't asking any of you to draft ballot language.
That may be top 25 at that point.
Yeah, like whatever it is, right? So the ballot language would come from staff. We'll be drafting ballots that meet the intent and the.
We get to see that. Not at a meeting, but we get to see that in any way before the council. Or is that just?
Well,
other
so
things?
when it goes to council, when these recommendations go to council, it will not be with ballot language.
Oh, okay.
Okay, it will be these sections, and this is the recommendation to change it and the why.
Okay.
Right? So, it will not be with ballot language.
Okay.
They'll be taking that after the presentation.
Correct,
So
so there,
we won't ever get to weigh in on ballot language.
Not as a committee.
As individuals.
Yes, as an
Voter.
individual and living in the state.
You can vote twice, huh?
yeah, you won't weigh in on how it's.
Somebody might get in trouble.
The election. When just looking through it, I mean, we do not have anywhere nearly as many recommendations as the last
And
committee.
that's okay.
It's fine,
It's
it's
not a
just,
challenge.
it's not a challenge, I'm just saying that it's not, the homework assignment is great, but it's not that much.
Yeah.
It's actually kind of
Yeah.
definable, that this is gonna be
I
fast.
think going a half hour early, we should be able to get through it.
Absolutely.
Let's do that.
Bring snacks.
There we go.
I can have snacks for the last
Hey,
time.
there we go.
I can have
Hey.
snacks. Okay, if I'm gonna provide snacks, do I have any food allergies?
Yes.
Dairy allergy. Milk, butter, cheese,
No
yogurt.
dairy,
No
oh my
dairy.
God. I'm gonna have to give you a hug. You take away my
I mean,
butter and
obviously,
cheese.
I'm not struggling to find
Oh
stuff
my
to
God, you take away my butter and cheese, and that's gonna be a fight.
eat. They make very good margarines these days.
No, they do not. No, because guess what?
I was in the emergency room 2 weeks ago. They're fine.
I can believe it's not butter.
That one actually has dairy in it.
Yeah, so, but okay,
I believe, I don't believe.
okay.
I can't have.
Shellfish, so no shrimp cocktail.
Okay, so no dairy, no,
I mean, it's not that,
so gluten.
GF.
No methamphetamine.
You can all select.
It's not that every single thing offered has to be dairy.
Yeah, I
We
can.
can have some options. We can have some options.
Yeah, I'll stay away from the cheesecake.
Okay,
I'll have your slice of cheesecake.
there you go. Anything else I need to be concerned with? Okay,
No other.
I'll have some kind of
Thanks,
snacks
Molly.
here so we can celebrate our last night. Okay, we'll have some options.
Awesome.
I like it. Okay.
Okay. Well, thanks everyone again. And our meeting is adjourned at 8:10:03.
Well done, well done.
Thanks, everyone.
Years.
Right.